The practice of set-offs, how private bankers test the limits of debt cancellation. One. The experiment. A small group of self-styled private bankers gathered to test a theory that debts could be offset against Treasury funds through creative paperwork. They began with the basics: utility bills, electricity, gas, internet, waste collection, water, and car insurance. Each bill became a test case for what they called a set-off. So what does that actually mean? It means they believed that instead of paying the bill, they could cancel it by filing certain IRS forms, the 1099-A and 1099-C, claiming that the debt had been discharged. Footnote. This section introduces the informal experiment by individuals attempting to settle personal debts using self-created set-off instruments. 2. The first wave. The first two set-offs went to the electric and gas companies. The gas company's general manager eventually called back, puzzled. "Our CFO doesn't know what to do with these," she admitted. She'd been doing taxes for 40 years and had never seen anything like it. The caller explained, the company needed to fill out Form 1099-C to claim Treasury reimbursement. The theory was that when a debtor sets off a balance, the creditor reports it as canceled debt, files a 1099-C, and gets reimbursed. Footnote. This section recounts the initial corporate confusion surrounding the use of tax reporting forms for private set-off claims. 3. The $600 rule. Then came reality. The company's accountant discovered an IRS requirement: the 1099-C applies only to discharges of $600 or more within a given year. Smaller amounts don't qualify. The revelation triggered silence on the call. Many bills were under that limit. So what does that actually mean? It means the Treasury isn't processing micro-debts from unpaid gas bills. The system has a minimum entry fee. Footnote. This section highlights the regulatory constraint that effectively blocks small value claims under the 1099-C reporting threshold. 4. The workaround. The group then pivoted. For debts under $600, they'd use what they called the receipt method. The plan was simple enough: pay the bill normally, collect the receipt, then submit it to the Treasury or a related office as proof of payment to recover funds. They discussed where to send these packets: Austin, Puerto Rico, or a Social Security regional branch. Nobody was entirely sure. Humor found its place here. "If the CFO ducks your call," one participant said, "tell him he's got 3 days to act before you fax the Treasury Inspector General." Everyone laughed nervously, half joke, half plan. Footnote. This section describes the group's attempt to circumvent the $600 limitation by shifting to a reimbursement model. 5. The paperwork maze. Each packet required a cover letter, the endorsed invoice, Form 1099-A, and a voucher labeled 1099-volt, a homemade document explaining how payment should occur. They debated whether to send originals or copies, whether to scan or fax, and how to address missing fax numbers. Some members lacked home internet and had to use library computers. Others used paid online fax accounts. The advice: always keep scanned copies and mailing proofs. The conversation sounded more like a startup logistics meeting than a financial rebellion. Footnote. This section illustrates the operational complexity and informal nature of the group's do-it-yourself administrative process. 6. The Inspector General angle. When companies refused to act, the group's next step was escalation. They would contact the Treasury Inspector General for Tax Administration, known by its acronym TIGTA. Phone numbers, fax lines, and post office boxes were read aloud. The theory: pressure through official oversight might compel compliance. So what does that actually mean? It means when your private banking theory hits a wall, you call the referee, even if the referee doesn't know the game you're playing. Footnote. This section explains the group's use of federal oversight bodies as leverage against non-responsive creditors. 7. The identity dilemma? The call wandered into stranger territory. One participant discovered that his birth certificate listed no first name, only a surname. This, he joked, made him legally non-existent. Another suggested filing an affidavit to correct the record, others thought maybe non-existence was safer. Humor aside, they agreed proper identification was essential before opening any accounts. Footnote. This section shows the group's drift into issues of personal legal identity and record correction as part of their financial process. 8. The philosophical detour. Toward the end, the group tackled an abstract question: if you endorse a receipt or bill to cancel a debt, are you participating in usury? The consensus was comforting: no. They framed it as a moral act, converting debt into credit and balancing the books. For a moment, the call felt less like accounting and more like theology. Footnote. This section reflects the ethical reasoning participants used to justify the legitimacy of their unconventional financial actions. 9. The practical lessons. When the laughter faded, the group settled on 3 takeaways. 1. Always keep documentation and scanning records. 2. Confirm the correct address before mailing anything. 3. If a company refuses to process the forms, escalate through official channels. Behind the confusion, a kind of order emerged, an improvised system of self-education. Whether it worked or not was another story. Footnote. This section summarizes the practical procedures distilled from the group's collective trial and error.